We're all involved in advising clients, and many here I think will be advising clients on the wealth creation process, whereas people like myself, we don't really know how to advise clients to make money, but we advise them how to give away their money, how to give away either for charity or to give away to the next generation, but at the end of the day to preserve their wealth in the long term for many, many generations to come. There is always this delicate balance between the creation of wealth and the preservation of it. And for people like myself, we look at it from the back end, I suppose, in that we look at how they would want to distribute their money at the end of the day, their wealth at the end of the day. Well, I'm not here really just to talk about the Muslim clients, because these concerns of distribution and preservation, succession planning are of concerns to everybody, not just those with any particular faith. This is of course because of all the reasons, the D's that we are all very familiar with, which I've put down there, and I'm sure I don't need to go into them, but mainly it is the desire to avoid all these D's that our clients come to all of us, or if as good advisors we should really identify that at the back of their mind they have all these issues swirling around. In particular, for certain of our clients, and in this respect I refer to the Muslim clients, when you talk about estate planning or succession planning, there are particular rules of distribution which you have to adhere to. There is what you call the inheritance rules of Fara'id, whereby I'm sure some of you are familiar that sons would inherit double of daughters, and where there are no sons, then perhaps siblings of the person concerned will be having a higher priority as compared to the daughters. And they have issues of polygamous marriages where there are more than one families. How would they go about dividing their wealth? And in accordance to Sharia, there are fixed shares. So I think in Europe also you have this, whereby the shares are predetermined. That is to say, you don't have a complete freedom of giving away your assets after death, not complete testamentary freedom, and there are forced heirship rules in play even in the certain European jurisdictions. And under Sharia, for example, adopted children are not entitled to inherit under the distribution system, but you can make a will for people like those, but the will a Sharia will is only effective as up to 1/3 of your assets only. You cannot will away more than 1/3, and this 1/3 is only supposed to be willed to the people who are not your heirs, such as adopted children. And in certain countries, for example in Malaysia, we have a dual system where when it comes to family matters and succession matters, divorce, then you are governed by the Sharia law. So that makes it quite confusing and also complicated set of affairs. So in general, there are many ways, I'm sure we're all aware, how to structure the succession planning for our clients. And the most common structures would be trusts and foundations, for example. These are commonly worked with, and I'm here today to speak more on the Labuan Foundation, merely because the Labuan Foundation it's very effective for these purposes that I just mentioned. And being civil law creation, Malaysia is also Labuan is in Malaysia, I'm sure everybody knows that, and we are a common law jurisdiction, but yet we are the first to have these civil law structures by enacting the Labuan Foundations Act. You can have either a private family foundation where you can structure it such that you can take care of your future generations, and you can have a purely charitable foundation, or you can have a hybrid of a charitable and private foundation. But in terms of Sharia compliance, Malaysia, as we know, is quite a leader globally in Islamic finance. Now that would be what I would term as a public sphere of Sharia compliance. There the laws are very clear, and principles have been formulated of what is Sharia compliant and what is not. Whereas in the wealth management sphere, Sharia compliance is still very much I think in the developmental stages, merely because this is in the private sphere, and in the private sphere, Sharia law is really a religious law, isn't it, as we all know, and many experts in the area are still, let's say, if they are willing to put out edicts or views on whether something is Sharia compliant in terms of Islamic finance, they may not be so willing to do so in terms of the private sphere of succession planning, for example, where it concerns faraid law. Well, the way in Labuan, how Labuan is very unique, it is actually the first in the world to have an Islamic foundation, and these foundations, Islamic foundations, they are set up where the aim of the foundation, the purposes are pure. They have to be in compliance with Sharia principles, and they have to have the Sharia advisor to advise. Well, as I mentioned earlier, I don't really want people to think I'm just speaking about Sharia compliant succession planning structures, because we also have what you call the conventional foundation. And I think a conventional foundation also, if you follow me through a little while, you will see that it also serves to be in a Sharia, to be in a way considered Sharia compliant without really having to be an Islamic foundation, so to speak. So if you think about a foundation and what it actually is, it's actually a combination of the best features of a trust and the best features of a company. The separate legal entity is the most useful point, whereby there will occur the separation of asset and ownership of the founder. So if you're the founder, you set up a foundation, you endow the assets, your assets to a foundation. When you die, those assets are no longer considered yours, so probate will not apply. Whether or not you're Muslim or non-Muslim, those assets are no longer yours. And of course, having a legal entity, it can sue and be sued. And the other good thing about the company feature of a foundation is that there are no shareholders, meaning to say that you don't have to get so many parties with diverging interests involved in the foundation. It can all be very, very clean, and as like a trust, it is a confidential structure. But people have said that trusts are a little bit inferior to foundations. This is mainly because of the issue of control. Because most founders we know, especially Asian or even non-Asians, they want to feel they are fully in control of their assets while during life, and also what happens to the assets after they are gone. So a trust, because there is the presence of this third-party trustee, and the fiduciary duties involved, it becomes more complicated, and so people tend to feel that a foundation situation is where the founder has more control. So those are the people, I'm sure you are familiar, who are involved in the foundation. Very similar to a company. The council members are like the board of directors, and the founder can be the council member and also can be the beneficiary. And the documents the constitutional documents are these, and this is where you put down what you want to happen to the assets in the foundation, whether you are a party involved in the foundation or you are not, but those documents will state clearly, and they are treated as contractual documents to be enforced by the council members and all concerned with the foundation. Well, as you can see, the issues that are clear: separation of ownership and from the person, and what happens because that property will no longer be the property of the foundation. And similarly, these are the features commonly found in all these structures. Is you can reserve your powers as a founder, you can reserve control, and then you can have a nominee founder. So that is when you assign all your rights to the nominee, and then later on nominee can assign those rights to you. And the foundation can move, arbitration, and confidentiality, as I mentioned earlier, very important in a trust, which is a feature of the foundation, is although there is a register, but that register is not open to public searches. And we have the common features of many foundations in different jurisdictions are these creditor protection rules, where the limitation period, if you have a creditor and those assets have been endowed to a foundation, it may prove to be more difficult for the creditor to attack the foundation, because primarily foundations are for the protection of the young and innocent generations to come. And these are the protections against all those Ds. And you also have the rights of the beneficiaries. Anyway, I have a very short time, so I'm not able to go in detail, but if you would like to know further, I will be outside. We have a booth, and also you can email me. Well, if it's a Malaysian property, you still have Malaysian income tax applicable, but otherwise it will be subject to the Labuan business activity tax, which is 30% or 3% or 20,000 ringgit. So those are the characteristics that I've mentioned earlier. And Labuan itself, it's a mid-shore jurisdiction. It's offshore, but with onshore laws. It's on the white list. It's equal level playing field, and English speaking, same time zone. Now, if I may just touch briefly on how it works in the Islamic foundation. When assets are endowed to an Islamic foundation, it is considered a hibah by the founder. So the founder gives the assets to the foundation, and that is considered as a lifetime gift. Hence, it would be in accordance to Sharia compliant, provided the three conditions are that there is the intention to go to the foundation, the offer and acceptance, and there's a complete transfer of ownership. And this has been validated by our Labuan Sharia Supervisory Council. So in a normal foundation, this is the Islamic foundation chart of how it works, to put it in a simpler way. And what might happen, because this is a foundation where the founder would want it to be in compliance with Sharia principles, so he would have a Sharia advisor or a few Sharia advisors, and he might divide those advisors into two separate committees. One being the investment committee, to determine whether the process of bringing in more wealth is compliant or not. And then there will also be the distribution committee, to determine that the distributions made to the heirs or to anybody for that matter will be in compliance with Sharia, and also Fara'id, which is the term for the distribution mechanism, the shares of who gets what. And the second chart I have is a regular foundation. But as I say, even a conventional regular foundation would also satisfy the requirement that it is a lifetime gift made during the lifetime of the founder. So, ladies and gentlemen, I hope I've given you some slight insight into the Labuan Foundation, and also a bit on Sharia compliance and how we might try to deal with it in a private wealth management sphere.